Statutory audit is a legally required independent or external audit to review organizations' financial statements. As for the case Cimb Investment Bank Berhad versus Ernst & Young and another appeal 2014, it's become a landmark decision in Malaysia law regarding the duty of care auditors owe to the third parties beyond their immediate clients. This case is a critical auditor's beware moment because it challenges the idea whether auditors conducting statutory audits specifically under the Securities Industry Act 1983 can be sued by outside investors for negligence.
For this case background, Cimb acted as a crucial middleman who directed its client to invest their money into SJ Asset Management, Cimb. When Cimb collapsed and the investment vanished, Cimb stepped up and repaid its client for their financial losses out of its own pocket because Cimb compensated its client directly. The court granted Cimb the legal right to sue the auditors, Ernst & Young. In essence, Cimb pursued the lawsuit to recover the fund it had already paid out to make the vulnerable investor whole again.
The legal issue, the main question is whether Ernst & Young owed a duty of care to Cimb Investment Bank Berhad for the financial statements they audited and or they could be held liable for economic loss suffered by Cimb. Meanwhile, specific questions that can be considered are: first, do auditors owe a duty of care to third parties who rely on the audited financial statements? Second, even if reliance is foreseeable, is there a sufficient proximity between the auditor and the third party? Third, did Ernst & Young assume responsibility towards Cimb when preparing the audit reports? And lastly, can Cimb recover for pure economic loss caused by a legal negligence in the audit?
The Court of Appeal ruled in favour of the investor, including Cimb Investment Bank. The judges held that Ernst & Young owed a duty of care not only to the company they audited but also to the investor. The court made an important distinction between two types of audits. First, audits under the Companies Act 1965 are mainly for shareholders. Second, audits under the Securities Industry Act 1983 are specifically meant to protect investors and ensure their funds are properly managed. Because Ernst & Young conducted audits under the Securities Industry Act, they had a responsibility to safeguard investors' interests. The court found that the auditors failed to detect and report suspicious activities, even though they had the power and access to do so. As a result, Ernst & Young was held liable for negligence towards the investor.
In the 2014 cases of Cimb versus Ernst & Young, the court ruled that the financial auditor have a strict legal duty to protect regular investors, not just the company that hired them. When investors hand over their money to a fund manager, they lose ability to monitor it, leaving them completely blind and vulnerable. Auditors, on the other hand, have full access to the company records and the actual power to spot money is missing. Because the auditor had the control to stop the financial disaster, but stay quiet, the court decided they are legally responsible for failing to protect the everyday people who actually own the money.
Cimb's initial claim against SJ Asset Management (SJAM) was founded on a breach of contractual duties, but the firm failed to fulfill its obligation under their 2003 Management Investment Agreement. The breach involved the false representations and mismanagement of approximately 106 million ringgit in missing funds made to induce Cimb into the investment agreement. EY argued that they had no contractual relationship with the investor Cimb and had fulfilled all contractual engagements with their direct client SJAM. However, the new ruling stated that the auditors owed a common law duty of care to the investors, showing a breach of EY's statutory duty due to its failure to alert investors of false claims.
The Court of Appeal established that statutory duties can be translated into a common law duty of care to the third parties if the purpose is to protect that specific group. So, the third party's investors may have a valid claim for the negligence. To conclude overall case, this case serves as a warning that the scope of an auditor's responsibility is expanding. Statutory audits are not just a box-ticking exercise for the company, but they are a shield for the financial ecosystem at large.
The angels up in the